How and when to bring a Rule 39 request? Well, you'll remember the quotation I put up from Mamat Kulo, an imminent risk of irreparable damage. Imminent risk is usually interpreted as meaning at the end of any domestic process that's taken place. So consistent with the court's rule on non-exhaustion of domestic remedies, the court won't intervene in a case while there are domestic proceedings pending, because it may be that those domestic proceedings will resolve the issue. So it will generally not consider any Rule 39 request while there are domestic proceedings pending. In fact, it will go even further and reject any Rule 39 request that's made while domestic proceedings are pending as premature. Now, that can often cause difficulties for applicants, because it means there can often be a very short period of time between the final domestic decision and any enforcement of that domestic decision. We saw this most commonly in the extradition context, where people would challenge their extradition from a European country to another country, most commonly a CIS country. They would have their final domestic decision and then they would be on the plane to that country within a matter of hours after that decision. Because of that, an exception evolved that the court will consider a Rule 39 request before a final domestic decision is made, but only in circumstances where there is really no time between the final domestic decision and the person's removal or surrender to a third state. That means it's a very difficult balance for applicants' lawyers to strike, because if they move too early, the Rule 39 request will be dismissed as premature, but if they leave it too late, they may be submitting a Rule 39 request that's only considered after the applicant is removed to the third country. My best advice under those circumstances is at least to maintain communication with the court. There's no harm in writing a letter to the court, explaining the situation, explaining why you're writing, and seeking the guidance of the court in those circumstances. And those letters will be looked at by registry lawyers who in most circumstances will do their best to help. So even if you're not making the Rule 39 request itself, you're at least advising the court that one is likely to arrive, and then people at least know that time needs to be set aside in order to consider it. A final point on that, though, is that the practice direction that the court issued tightened up the rules on when Rule 39 requests in immigration and extradition cases should be submitted. And it says that there should normally be at least one working day between the Rule 39 request and the applicant's proposed removal or surrender. And that means one clear working day. So if someone is to be removed on a Friday afternoon, then the Rule 39 request should really be received by Wednesday afternoon. That's a very strict rule, perhaps too strict in my view, but that is the rule that the court and its registry have chosen to apply. So if in my example you haven't submitted the Rule 39 request by Wednesday afternoon, there's a risk, in fact it's very likely, that it simply won't be examined by the court. So that's something really to watch, and it's obviously very difficult in cases where someone might be removed very soon after a final domestic decision. I mean, I'm sorry I can't offer more guidance on that, other than, if that's not advice, at least it's a warning, and it's something to bear in mind, that you take instructions as early as possible from your clients, and that you communicate with the court as early as possible. I know that's unsatisfactory, but that's the best advice I can offer, as long as the court maintains this one working day rule. Before I go on to talk about evidence, I would say that the best Rule 39 requests are usually ones that are short and to the point. I think that's true for any legal submission, but it's particularly true in the Rule 39 context, because things can happen very quickly for all of the reasons I've mentioned. And it's much better that you submit a short Rule 39 request that can be quickly considered by the court than spend a lot of your own time preparing a very long Rule 39 request that isn't going to be considered in as much detail as by the court because of its length. I will come back to this when I talk about some of the common errors. A short Rule 39 request doesn't mean that it should be unsupported. It's often better, I think, to do a short Rule 39 request but to submit a lot of evidence than the other way about. So for that reason, I'd like to spend perhaps 5 minutes just talking about evidence in two forms. Firstly, the evidence that would have to be submitted in a removal case, so an immigration or extradition case, and then the evidence that would have to be submitted in a health case. The obvious thing to do, but you'd be surprised how many times people fail to do it, is actually to submit all of the domestic decisions, because those are the first things that any international court reads. And that should be unsurprising, because it's only deciding a case after it's been through a domestic legal system. And for any superior court always starts by looking at the judgment of the court below it. And the Strasbourg court is no different. But the Strasbourg court obviously needs all of the domestic decisions, which might be 3, perhaps even 4 instances in some countries. So all of them have to be submitted. And in many cases, the Rule 39 request simply won't be considered if the domestic decisions haven't been submitted. So it's an obvious point, but you'd be surprised how many people overlook it. The second point is to submit as much country information as possible. But here I would emphasise that it's much better to submit short, specific reports that speak directly to the issue in your case than to submit, say, Amnesty International's report on human rights in the country concerned. It's much better to submit extracts from reports like that, or to submit reports from NGOs that speak directly to the issue you're concerned with, rather than to put general information before the court, which tends not to be of much assistance. Another obvious point, but one that's often overlooked, is that, like any court, the Strasbourg court cannot know all of its jurisprudence, because it decides too many cases every year to be able to do that. So there's certainly no harm in taking the court to its own case law and outlining any cases, particularly recent cases, that are directly on point to your case. Here again, I would emphasise that it is much better to actually put short, specific points and extracts from those judgments than to attempt to submit all of the judgments themselves. But I wouldn't stop jurisprudence of the Strasbourg court. Not only can the court not keep up with its own jurisprudence, it can keep up with everything that comes out of the United Nations bodies, the Inter-American bodies, or national courts. So as long as judgments from those bodies are relevant and they're in a language that the court or its registry lawyers can understand, there's certainly no harm, and it's probably even beneficial to submit that kind of information to the court. But I would keep all of the evidence that you submit in these cases manageable, because, as I've said, you simply don't know how much time the court can actually devote to considering these cases. Your application might arrive on a day when that's the only thing the court or the Vice President has to consider, but it may also be that it arrives in the same time as 20 other Rule 39 requests from all different countries. So you really have to build in that possibility to your advocacy. The same thing can be said about medical cases. Here the rule is, I think, to submit all relevant material, including evidence on, say, the conditions in the place of detention or even the hospital where the person is being cared for. And the most obvious one to submit in this circumstance is the applicant's medical record. So it's usually a good idea, if you know that this issue is going to go before the court in an application you're making, to obtain consent early to be able to disclose the applicant's medical record to the court. And where possible, to get independent medical reports. Alex Sanyan and Amirov, I think, are 2 very good examples of advocacy before the court, because in both of those cases, the applicant's representatives weren't able to get the applicant examined physically by one of their own doctors, but what they were able to do was to take the applicant's medical record and show it to independent consultants, who were then able to provide medical reports based on their analysis of the medical records. Those independent medical reports were, I think, decisive in the court's decisions in those cases to grant interim measures under Rule 39 of the Rules of Court, and also to go on and find violations of Article 3 in those 2 cases. I appreciate that inevitably involves a lot of work and places a great deal of responsibility on the applicant's representatives, but it's really impressive when people do it, and it's really the only way an international court can decide such cases. Common errors. I've mentioned already premature applications, and I've mentioned late applications. I've mentioned also prolix applications, and I would really just emphasise that point about remembering time constraints in the court. And on reflection, I should probably have said remember the time constraints on the Vice Presidents, because they're the ones that actually deal with all of the Rule 39 requests. And in addition to doing this work, they're also doing all of their other work at the court. So it can be a lot of work for them to manage. And when you're dealing with requests that can come in from 47 contracting states, it's unpredictable, as I've said. The volume of Rule 39 requests is unpredictable, and sometimes it can be very quiet, and then suddenly, for no reason, as I've said, 20 Rule 39 requests can come in from 20 different countries, and one of the Vice Presidents has to do all of them. So it can be a day where he or she just does one, It can be a day when they have to do 20 urgently under very pressing circumstances. And for that reason, the shorter the application, I think, the better. Two other common errors is failing to submit the application form after the request is granted. As I said, when Rule 39 is granted, the object is to get the case back on the normal track as quickly as possible so that it's treated the same way as any other case before the court. And that obviously requires an application form to be submitted. And again, you'd be surprised how many people think that because they've put in a Rule 39 request, and that request may contain all of the information that you'd normally put in an application form, that they don't have to submit an application form, that they've already done that. Be really careful about that, because if you don't submit the application form, there's a real danger that the court will take the view that you're failing to pursue your application and may strike it off under Article 37. Another common error that's perhaps more understandable is the failure to submit an authority form. Now, the court's become really strict on this and requiring applicants to show that they actually have authority to represent someone. That's true in all circumstances, and cases will be rejected because the court isn't satisfied that this representative is actually acting for the applicant. Now, the reason that's difficult in the Rule 39 context is that if you have an applicant who's just about to be deported or extradited to a third country, then it's very difficult to remember under those pressing circumstances that you need to get a signed authority form for that client, because it may be too late if that person's deported or extradited. And it's a really strict rule that the court applies now. In ECtHR, which is a recent decision from this summer, the applicant was removed to Uzbekistan and disappeared. And there was an obvious suspicion that the disappearance was at the hands of the Uzbek authorities. And it was likely that Russia had failed to comply with its obligation under Article 3 of the Convention to prevent this real risk of ill treatment by sending the applicant to Uzbekistan. But what had happened was that the applicant's representative had failed to get an authority form from him before he was sent to Uzbekistan. And she'd also failed to get an authority form from his family members who'd remained in Russia. And despite the fact that the applicant had disappeared, probably at the hands of the Uzbek authorities, the court decided that without an application form, there was no evidence that this representative had the authority to act for the applicant ECtHR, and therefore declared the case inadmissible as incompatible ratione personae. So it's a tough rule, and again, perhaps the best advice I can give is by way of warning. Even in this very fast-moving, highly pressurised situation of making a Rule 39 request, don't forget to take an authority form, a signed authority form for your client, so that you can pursue the case, even if he is returned to a third country.